Welcome everybody to another question and answer session live. My name is Samara Belitzky. I'm an employment lawyer at Samfiru Tumarkin, and I work out of the firm's Ottawa office. I'm here this afternoon once again to answer all of your questions related to the workplace and employment law. So any questions that you have, I'm going to be here for the next half an hour to answer all of your questions, as I mentioned before, related to the workplace. So anything related to COVID, vaccination, health and safety in the workplace, terminations, harassment, severance, you name it, I'm here to answer those questions. So send in your questions and I'm happy to answer them. If anything you've been thinking about for the last little while, if you've asked questions in previous sessions that unfortunately we didn't get to, now is the time to send in your questions to make sure that we have time to get to it and to answer it today. As always, if you don't want to ask your question live, or if we don't get to you today, you can always go to our website, employmentlawyer.ca. We have lots of resources on our website that you can access. You can also use our website to access our contact information. So our general contact information and all of our firm contact information, my contact information, it's all on our website, and you can contact me directly or any of our other lawyers that way as well. You can also email us at help@employmentlawyer.ca in order to have somebody address your issue as well. So you have lots of options available to you, but right now I'm here for the next half hour to answer your questions. So if you do have something that you've been thinking about, whether it's you, a friend, a family member, you've had something on your mind, feel free to send it in so that we can address it and we can discuss it and find a solution or give you some assistance with whatever it is that you're dealing with. As always, I have a few items on my list here of things to talk about today, things that have come up in the news over the last week or so, and things that we've been getting a lot of questions about from clients and from people like you who are watching today. So I will get to those items. I see we have a couple questions coming in, so I'll start answering questions and then I'll go back to my list if we have time. So the first question I have here that's come in from YouTube is, are employers required to pay employees for travel time going to clients? So when we're dealing with an employee where part of your duties are to travel, so in order to carry out your job, you have to travel. And I think what this individual is talking about is, maybe you're a salesperson, maybe you're going to visit different clients throughout the day within the geographic area where you work, then that time is work time and you should be paid for that. I see there's a follow-up example here from the person who asked the question. The example is, if the employee's schedule is 9 to 5, but they have to meet a client at 9 a.m., do we pay them for, say, 1 hour travel time? Okay, so I think you're asking this question as an employer with respect to your payment obligations. So in terms of the situation, it will depend on the circumstances for the example that you've provided. Generally speaking, if the travel time is part of the employee's duties, the employee must be paid. As an employee, you have to be paid for all the time that you're dedicating to carrying out your work. There are certain exceptions to that. So, for example, if it takes the employee an hour to drive to work, for example, and that same amount of time would be used to drive to a customer or a client in the morning, that's a situation where there could be an offset. Doesn't necessarily mean that the employee is going to be getting paid, because they may be spending that same amount of travel time to attend at the workplace versus going to a client's premises. Now, when we're dealing with an employee going to a client's workplace or going to somewhere other than the head office or the place at which they normally work, because the employee is still carrying out their duties and doing their work at that place, that other place is also considered part of the workplace, and that employee is considered to be at work when they're there. And so if part of the employee's duties are traveling there and attending there, that would be considered part of the work and part of the workplace. And so the circumstances, as I mentioned before, will be really important in order to determine exactly how the employee needs to be paid. Do they need to be paid for the entire travel time, or part of it, or none of it in very, very limited examples or circumstances? So if you're an employer dealing with this issue and you're not sure what to do, get in touch with me. I'm more than happy to review the situation with you and let you know where you stand from a legal perspective, what you have to pay the employee. Because from an employer perspective, you want to make sure, which I'm sure you do, which is why you're asking this question, that you're on the right side of the law here, that you're paying your employees how you should be, and that you're not exposing yourself to liability for not doing what you're supposed to do. And on the employee side, the takeaway is, you want to make sure as well that you're getting paid when you should be getting paid, and you're getting paid for the work that you're doing. Most of the time, it does include travel time, but again, it will depend on the circumstances. So whether you're an employee or an employer dealing with this particular issue, reach out for legal advice. Make sure you speak with an employment lawyer in order to figure out exactly where you stand on this issue, and to make sure as an employer, you're complying with the law, and as an employee, you're getting exactly what you should be for carrying out your duties in terms of compensation. So I have another question that has just come in, not really a legal question, but a question asking about whether we charge for an initial consultation to discuss matters. So generally speaking, most of our initial consultations are free. There are some situations that are more complex that do require a longer consultation, and there are scenarios where there will be a fee for a consultation. So keep that in mind. In most scenarios, when we're dealing with especially LTD matters, but in the employment law sphere, most terminations, there will be usually a free consultation. Again, that doesn't apply to everything. I can't be more clear. It is not always the case. There are certain situations and certain cases where a more in-depth analysis is involved, a longer consultation is required, and in that case, there will be a consultation fee. But the best way to find out is to call us, get in touch with us, speak to somebody in our intake department. They will take your information and they will assess the situation and let you know where you stand and what type of consultation is required in your specific situation. So definitely give us a call. The number is on our website. It was just on the screen. You can give us a call. You can email us at help@employmentlawyer.ca. Our website, again, is employmentlawyer.ca. So all of our contact information is there. That is your first point of contact. Get in touch with us so that we can assess your situation and see what your options are and what the next steps can be from there. I have another question from YouTube with respect to an employer, I believe. I don't have as many questions coming in this afternoon as I usually do, so I'm happy to answer your follow-up question. And everybody who is watching this afternoon, please don't be shy to send in your questions. Usually I don't get to all of the questions because we have so many, so now is a really great time to make sure that your question gets answered while I'm here. So please send in your questions. I'll get to this follow-up question though. Can the employer ask the employee not to come into work if they haven't provided an FAF and they suspect they're not fit to work? So for those who are watching and not aware, an FAF stands for Functional Abilities Form. And a Functional Abilities Form, or an FAF, is a form that an employee will sometimes need to have completed by their doctor when they're returning from a medical leave. So generally speaking, when an employee goes off on a medical leave, when they are cleared to return to work, and usually it has to be an extended period. So if, let's say, an employee is only off work for a week or so because maybe they're sick, maybe they have COVID, or they have a cold or the flu, that's not generally where an FAF would apply or a functional abilities form would apply. It more would be for longer periods of absence, a longer medical leave, where the employee may be physically injured, or there might be a mental health condition that would prevent you potentially from doing parts of your job or parts of your job as it was prior to your leave. In those scenarios, as an employee, you have to let the employer know as soon as you're clear to return to work in any capacity, whether it be full-time, no restrictions, same as before your leave, or if there are restrictions, in an accommodated role. And that can be reduced duties, reduced hours. It can look like however it needs to look like in order to accommodate a medical condition or restriction that's being caused by a medical condition. In that scenario, when an employee is returning to work, the employer actually has an obligation to make sure that they're not having the employee do any work that could risk an issue with respect to health and safety. So the employer has a duty to provide a healthy and safe workplace for every single employee. So in a case where the employee is returning to work, the employer has a duty to make sure that the employee can work, that from a medical perspective, the employee is able to work, they're able to carry out their duties just like before. And if they're not, then the employer has an obligation to make sure that they're accommodating them. So for example, if somebody's going back to work and they're in a labor-intensive job where they can only lift up to 5 or 10 pounds, that needs to be made clear to the employer, usually through a doctor's note or an FAF, a functional abilities form, to make sure that the employer is aware of it and they can accommodate that and make sure they're not having that employee lift more than the 5 or 10 pound restriction that they have in place. So it really is a cooperative and collaborative process between the employee and the employer to make sure that that happens and that when the employee goes back to work, it's a healthy and safe environment. Now, with respect to the FAF, as I mentioned before, some employers will ask for a medical note. If the medical note, basically specifies that the employee has no restrictions, can go back to work, same as before, clear to return without any accommodation required, that is pretty clear. In a case like that, it wouldn't necessarily be reasonable for an employer to ask the employee to have an FAF filled out by their doctor because their doctor's already been clear. However, in the case of ambiguity, if it's not clear that there are no restrictions and no accommodation required, if the employer is unsure as to something, then they can ask for that form to be filled out. They can, in a way, kind of satisfy themselves that this employee is coming back and they're aware of what are the restrictions or accommodations required, if any, so that the employer can comply with the law. So in some of those scenarios, asking for an FAF would absolutely be reasonable. And as an employee, you have a duty to cooperate, to collaborate with the employer on your return to work and get that form filled out by your doctor so that you can get back to work in whatever capacity you can. Specifically, as an employer, if you are unsure about whether the employee is fit to work, coming back to your question from YouTube, that is where an FAF can come into play. So if there is a question, as I mentioned before, if there is a doubt as to what the employee can or can't do, then yes, you can ask for an FAF. And as an employer, I would actually suggest you do that in order to make sure that you are complying with the law and you're not going to be putting the employee in a situation that's unsafe or unhealthy for them coming back to work. But it has to be reasonable. So again, if you doubt as an employer that they can return, but their doctor has provided a note that makes it crystal clear that they can return and they have no restrictions whatsoever, then you wouldn't really have a legal leg to stand on in terms of doubting that ability. Now, if the employee comes back to work and starts to have issues where you think they might be getting injured, they're not able to do their job properly, then that issue gets raised again with respect to their ability to do their job. And at that point, you can make certain inquiries, but again, always coming from a place of making sure that you're creating a healthy and safe workplace for the employee. And again, if there's a specific scenario that you're dealing with, please get in touch with me. I'm very happy to go over the situation with you in detail. There are never two identical situations. Every situation is different. And before you do act, whether you're an employee or an employer, it is always best to get legal advice from an employment lawyer first to make sure that you're complying with the law or as an employee that you know what the law says about your situation and you can protect yourself. So I have a question here from Tiana on Facebook, who says, I worked at a small company and was laid off 3 months ago. I was told I'd be brought back, but so far heard nothing. Can I ask for severance now, or do I have to wait? So the only way that a layoff would be permitted initially is in one of two scenarios. Either as an employee, you've signed something that says that the employer is allowed to put you on a layoff. So that can be something like, for example, an employment contract that you may have signed when you started. Sometimes employers will insert language in those contracts where they get you to agree that they're allowed to put you on a temporary layoff in the future. So that's one way that the employer can be permitted to do that. The other way, as I mentioned before, is if you sign something, at the time of layoff that says you're agreeing to it. So that's one way that the employer is allowed to do it. The other way is if they've laid you off before, you haven't refused it, you haven't raised it as an issue, you've gone back to work when you were recalled, back to work, business as usual. That then becomes a precedent. It becomes a term of your employment moving forward. And it then allows the employer to do it again if they want to. And so that's why whenever you're dealing with a layoff, if you don't fall under the categories I just mentioned, you've never signed anything that says they can lay you off, you've never been laid off before, this is the vast majority of employees. Most employees have not agreed to it in writing and they don't have a previous layoff. If you fall under that category, the employer does not have an automatic right to put you on a temporary layoff. And if they do, you can treat it as a termination and go after your severance. And in fact, to answer your question, Tiana, you should pursue it right away if you are going to pursue it. You have a choice. You can accept the layoff, but keep in mind if you do, that becomes part of your employment terms moving forward, and they can do it again and again and again. So that's why it's important to object to it so that you stop the employer from being able to do it again in the future. And if you are going to pursue it, you should pursue it sooner rather than later. So if you are going to treat it like a termination and go after your severance, now is the time, Tiana. You don't want to wait. It's been a few months. You don't want to wait longer than you already have. Get in touch with me. I'm more than happy to help you with this. If it is in fact a situation where you've been, your employer doesn't have the right to lay you off, you can treat it like a termination and you can go after your severance. And that's something that we assist people with all of the time. And certainly I'd be happy to assist you with that. So you can get in touch with me. My contact information is on our website, employmentlawyer.ca. You can find my profile and my contact information and feel free to contact me directly. Otherwise, you can contact our firm generally, but you should move ahead on this sooner rather than later so that you're not sitting around and essentially giving the employer the opportunity to recall you before you take any action on this. So I'm just reading through a question that was over a few different messages. I have a question from Asim on YouTube who says, hi, I have a parent overseas that had an unplanned urgent surgery. My sibling took permission to go take care of our parents. She's on a leave of absence and gave a date to go back to work. Due to complications with the surgery, she needs to delay by a few weeks. Could she be fired as she has to extend the leave of absence? Can her company, a bank, reject her request and fire her for this? So generally speaking, the type of leave that you're talking about for the reasons that you've mentioned is not something that absolutely has to be required by law. There is caregiver leave that is governed by the Employment Standards Act. If she works for a bank, she's actually governed by the Canada Labour Code because banks are federally regulated. So the Canada Labour Code governs the employment relationship or the bare minimum obligations and rights in the employment relationship for banks. Otherwise, in Ontario, it's the Employment Standards Act for provincially regulated companies. So there are certain types of caregiver leaves that aren't earmarked by the legislation, but they do only apply to certain circumstances. So it will depend on the nature of the surgery, the nature of your parent's illness. So if it is an illness that is very, very serious, that could fall under the caregiver leave provisions. In addition to that, if let's say it doesn't fall under that leave, but the company has provided a leave anyway, as an employer, I would always recommend, to provide the leave to the employee as long as it's reasonable, as long as it's feasible. That certainly is the right thing to do. I would expect that because they provided this leave to begin with, they would likely be open to extending it, but she does need approval, or yes, she does need approval to extend it. So in a circumstance like this, you have to get your employer's approval in order to extend your leave. Otherwise, your absence is unsubstantiated, it's unjustified, it's not approved. And going on a leave without your employer's approval can provide them with reason to terminate you, sometimes for cause, depending on the situation. And so you have to be very, very careful as an employee with these scenarios, to be in communication with your employer, very transparent, making sure that everything is approved in writing. That is very important, so that you have that to fall back on if ever there's an issue. Now, with respect to the extension, again, depending on the situation, it may be covered by the legislation. If it's not, all she can do is request an extension. If they don't allow the extension, then it becomes a situation where the employee is refusing or failing to report to work. And that can lead to a termination, or it would also be considered a resignation or an abandonment of employment, because when the employee is not coming into work, the employer can treat that as a resignation or an abandonment as long as they verify it. So if somebody as an employee doesn't show up to work one time, an employer can't just treat that like a resignation or an abandonment out of nowhere and just say, okay, we accept your resignation, have a nice life. It has to be confirmed. It has to be verified. So the law requires that an employer actually take steps to check these things before they just take it as a given that somebody has resigned from their job. So this situation, Asim, it is a little bit complex. It is a little bit complicated depending on the reason for the leave and where your sibling left it with the bank, with her employer. I would recommend, if she's not sure what to do, to get in touch with us, and we can help guide her so that she's in the best legal position possible. But step one would absolutely be requesting that extension, seeing how the bank or the employer responds from there, and seeing if some sort of compromise can be reached, especially if it's only another couple of weeks. If they've already accommodated her for a little bit of time, it's probably feasible. It's probably something that can be done, but it does require a dialogue between the employer and the employee. And if that doesn't work and she does have issues, certainly please let her know to get in touch with us. Happy to help her however we can. So I have a question from Michelle on YouTube, who says, I got terminated for not getting vaccinated from the non-union airline I work for. No severance. Is there a lawyer that can represent many of us to avoid these high lawyer fees? So, Michelle, you've asked a question that we've gotten a lot over the course of the last, I'd say, 7 months or so, which is with respect to class actions on vaccination issues. So it's really important to understand that a class action is only suitable for very limited types of cases. And in a case with respect to vaccination, there are too many different variables for every individual employee in order to proceed in the manner that you've mentioned. So within a class action, the class members, the terminated employees, would have to have a lot of things in common in order for it to work, in order for a class action to be the best way for them to pursue your entitlements. And in these cases, it wouldn't be. In these cases, individuals would be far better served with individual claims. And that's with respect to, I'm speaking generally when we're talking about vaccination cases, terminations. You're much better served as an employee in pursuing your rights if you pursue it as an individual claim rather than a class action in this particular type of scenario. Because as many of you watching probably know, when we're talking about severance, it's based on several different factors. Age is one of them. Length of service is another one of them. All of you will have different ages, different lengths of services, different compensation, different positions. So it's very hard to have that be addressed in a kind of common manner. You're much better served going through an individual claim process or an individual court process. It's much faster. You'll end up getting what you're owed much, much faster than going through the class action process, which takes years and years. Now, with respect to working for an airline, so in terms of the transportation industry, there has been government mandates with respect to being an employee in the transportation industry and needing to be vaccinated in order to work. So that is something that would apply depending on your position. But if you are working for an airline, it is likely covered under that transportation mandate. And so we'd have to look at the circumstances of your situation very carefully to see if there is something that we can do to assist you in pursuing severance. If it does fall under the government mandate, which essentially changed the law when it comes to vaccination for certain areas of the transportation industry, there won't be very much that any lawyer can do for you, regardless of the legal fees, regardless of anything. If you don't fall under the mandate, most people don't, but Michelle, in your situation, you might. If you don't, then absolutely, if you were terminated for not being vaccinated, then absolutely you're owed severance, and we can assist you in pursuing that, just like we have been for many, many, many people since this all started to happen last year. We've been pursuing severance packages for lots of employees who have been let go because they're not vaccinated. And again, the caveat is as long as there was no government mandate in place at the time that happened, which for most people there was not. The only vaccine mandate that the provincial government put into place is with respect to long-term care homes. The other mandates that were put into place, for example, in the healthcare sector, were with respect to options of rapid testing or vaccination. But at the federal level, we do have the core public administration, so most employees working for the federal government, as well as the transportation sector. So there are different mandates at play, which unfortunately have changed the law on this. But if you don't fall under any of those mandates and you have been terminated for refusal to be vaccinated, then absolutely you are owed severance, and you should get in touch with us right away to pursue your rights and to pursue your entitlements so that we can get you what you're owed. All right, so I'm just at the end of our time for today. Unfortunately, I didn't get to my list, but we can always talk about these things next time. If you do have any other questions for us, we do have more question and answer sessions live next week, starting on Monday, I believe at 3 p.m. in the afternoon. But we do have a few lined up for next week, so please do join us for those and ask your questions then. Otherwise, you can go to our website at employmentlawyer.ca and contact us that way. Thank you very much for joining us today, and I hope that everyone has a wonderful weekend.